Centuries-old dispute now resurfaces in Varanasi. Hindu petitioners seek permission for year-round access to pray at the shrine inside the mosque complex. The Kashi Vishwanath Temple Gyanvapi Mosque row has put the spotlight on the Places of Worship Act 1991. What is the case and the Places of Worship Act? We explain.
Now you have a dispute arising from it. Some 5 Hindu women recently went to a court in Varanasi, and they wanted the right to pray there. There's an idol behind the western wall of a Devi idol behind the western wall, which they want to worship, which they say they have been worshipping. People have been worshipping for many years, and now they want to continue the worship. So, hearing it, the court appointed, as in every civil dispute, what a civil court does is it appoints a commissioner. It appoints a lawyer as a commissioner to go to the site, see the facts, and submit a report, prepare a report and submit it to the court. So here also they have appointed a commissioner to go into it. There were controversies regarding who should be the commissioner. The court appointed a lawyer. The Muslim side took objection to it. So they went back to the court saying, no, somebody else should be there. But the court retained him. But the court appointed some other people also to assist him. They went and checked. Meanwhile, this Muslim side then went to the Allahabad High Court, stating that these orders of the trial court were in violation of the Places of Worship Act. They raised this plea in the trial court also. The Allahabad High Court dismissed their petition, against which they came to the Supreme Court. So that's how the matter reached the Supreme Court. On April 21, the Allahabad High Court dismissed the petition, against which they have appealed to the Masjid Committee has appealed to the Supreme Court. The court said we have to balance both sides. So what did it do? It restricted the scope of the Varanasi court's order. So to explain that, we'll have to go back to what happened in Varanasi. To understand that, we'll have to go back to what happened in Varanasi. In Varanasi, an application was moved by the Hindu side, claiming that a shivling has been discovered during the survey. So the place where the shivling was found should be sealed. 2, entry of Muslims to the mosques should be restricted to 20 at a time. And 3, the Wazu Khana, in the middle of which the shivling was allegedly found, should be close to. Means nobody should be allowed to use that Wazu Khana anymore. So the Hindu side filed this application with these 3 requests. Now, hearing that, the court gave an order in which it said, yes, seal the place where the shivling was found. However, interestingly, it's a bit of a legal technicality. Interestingly, at the end of the order, the court says the application is allowed. Application of the Hindu side is allowed. Now, if you say the application is allowed, it would mean that all the requests sought for have been allowed. But, which means the sealing of the place, the non-usage of the Wazu Khana, as well as restricted entry for Muslims, all the 3 have been allowed. However, when in its explanatory part, the order only says that the shivling has to be protected. So the Supreme Court was in a bit of a confusion whether the trial court has granted all these three requests or only granted the request for sealing of the place. So it said we need more clarity on that. It has asked the Uttar Pradesh government to explain it. The government, state government will explain it in the next date of hearing. The principal contention of the Muslim side is that the orders of the trial court appointing a commissioner to examine the site is in violation of the Places of Worship Act. So what is the Places of Worship Act? This was a law enacted by the Parliament in 1991. P.V. Narasimha Rao was the Prime Minister then. The Congress was in power. 1991, you should remember, that was also the time when the Ayodhya issue was at its peak. And there were all kinds of political opinions. There was BJP supporting it. The Congress had its own political stance. It is in this background that they have brought out this law. So what does this law say? This law says that after this law sets a cutoff date, August 15, 1947, and says that every religious structure, every place of worship, in whichever form they existed on this day, it will continue to exist in that format. It changed. Not just that, no suit or no petition can be filed. Nobody can go to a court seeking a change, seeking to convert it, anything. Nothing like that can be done. But interestingly, the Act exempts Ayodhya from its purview. This doesn't apply to Ayodhya because as we can understand from the parliament debates of the time, the ruling party also, the government also wanted, the Congress which was in power, then also wanted they wanted to have a peaceful solution to the Ayodhya issue, that people should talk to each other and find a solution, and that maybe they also felt it was not a matter for the courts to deal with. But interestingly, this Places of Worship Act itself has been challenged in the Supreme Court. 2 petitions have been filed, and in one of them, the Supreme Court even issued notice last year, in March last year, to the centre, seeking its view. However, the centre is yet to reply to that notice. Why has it been challenged? There are 2 parties. There are 2 parties which have challenged it. One is an advocate by name Ashwini Upadhyay, and the other is by a Lucknow-based trust, Vishwabhadra Pujari Purohit Mahasangh, along with some faithful. So these are 2 petitions. On Mr. Upadhyay's petition, the Supreme Court issued notice in March last year. Now the main contention, what is their contention? Their contention is that this act is unlawful, unconstitutional. Why? Because, see, you cannot make a law which forbids any citizen from going to a court. That's per se unconstitutional, is their contention. So this bars the courts from judicial review, this law. That's a contention. That's what they want to be addressed. The court has taken it on board, issued notice. Now we'll see what happens. When the law was enacted, we have to just go through the parliament debates where we see some very strong stands taken by leaders like Uma Bharati, who said this is not the way to address historical wrongs, that this will only keep them alive, that we should in fact address this with more honesty, and only then will people reconcile to the facts. So that has been the BJP stance then. The Muslim side, while arguing that this is, whatever is happening is in violation of the Place of Worship Act, has also sought to argue that it is in violation of what the Supreme Court said on this act in the Ayodhya judgment. Yes, it's true that in the Ayodhya judgment, the Supreme Court commented elaborately on the Places of Worship Act. In fact, the court said that the act is a legislative instrument designed to protect the secular features of the Indian polity, which is one of the basic features of the Constitution. But however, from a purely legal point of view, there is a problem here, because the merits of the Places of Worship Act or the constitutionality of the Places of Worship Act was never an issue before the bench which heard the Ayodhya case. Because, as I said before, Ram Janmabhoomi Babri Masjid was already exempted from the Place of Worship Act. So, at best, it's an opinion by the court. However, whether the constitutionality of the act will still have to be decided in those two petitions which are pending before the court. What is the BJP stand of as of now? I don't think we would be able to delve deeply into that, because there is nothing official on record. Also, you must remember that this is a matter sub judice. This is a matter pending before the courts. So no political party, no responsible politician would comment on it. That will be, that will not be, that will be impropriety. They wouldn't do that. Also, in the Places of Worship Act, the Supreme Court has already issued notice to the centre. So the centre will explain its stand in its reply. We'll have to wait for that.